Anuradha Bhasin versus Union of India 2020. Is the Government of India empowered to impose a complete shutdown of internet services? If yes, can the shutdown go on indefinitely? Further, if a government imposes a ban on internet services, can that order be subjected to judicial review? Anuradha Bhasin versus Union of India case is associated with the challenging of law and order restrictions and orders passed by the executive in the light of the abrogation of Article 370. In this case, the Supreme Court declared the right to practice profession and trade over the internet as a fundamental right under Article 19, Clause 1, Subclause G. Background: the constitutional order abrogating Article 370 in the then state of Jammu and Kashmir was accompanied by restrictions on movement, shutting down of mobile, internet, and other such services. In light of such circumstances, journalists claimed that restrictions on movement and unavailability of internet services hamper their right to freedom of speech and expression and freedom to carry out any trade and profession. Therefore, a writ petition Supreme Court challenging the same under Article 32. Legal issues involved: whether the government can claim exemption from producing all the orders passed under Section 144 or CRPC and other orders under the suspension rules. Second, whether the freedom of speech and expression and freedom to practice any profession or to carry on any occupation, trade, or business over the internet is a part of fundamental rights under Part 3 of the Constitution. Whether the government's action of prohibiting internet access is valid. Whether the imposition of restrictions under Section 144 or CRPC was valid. Whether the freedom of press of the petitioner was violated due to the restrictions. Arguments: the petitioner argued that the ban on the internet has resulted in bringing press and media to a grinding halt. The orders passed under Section 144 or CRPC are not accompanied by valid reason from the government. It was pointed out that the order of the magistrate under Section 144 cannot be passed to the public generally and must be specifically targeted against a group which is likely to disturb the peace. Further, the petitioner argued that the orders are passed only on the apprehension of danger to law and order. There is no concrete evidence of any such risk. Hence, a balancing of measures is required between national security and curbing terrorism.